Welcome back into Sports Blitz Live. Luke Robinson, Adam Blankenship. And for anybody who's not a fan of Alabama, you can set your jimmies to rustled right now, I think, because a lot of people are upset about the Cam Robinson Hootie Jones charges being dropped. Well, we have a guy on the phone now that may be able to answer some questions and what really went on in this case. Mr. Robert Moseley, an attorney from Mobile. Robert, how are you tonight?
I'm doing just fine, guys. How are y'all?
Doing great. Thanks so much for being with us this evening. So, look, you know about this case, I'm sure. Everybody in the world knows about this case, it seems like. So what ended up happening in the end?
Well, as far as what I know about the case, I only know about as much as everybody else does from reading the Internet. A lot of the facts of this case were sealed due to the juvenile status of both defendants, or the two primary defendants, be Cam Robinson and Hootie Jones. But from what I understand, everybody understands, the prosecutor didn't feel like he had sufficient evidence to lead to a conviction, which was the end result. But I think that the question that everybody's been asking, or at least on the radio, from what I understand, is, did the status of these two gentlemen as being football players or football players at the University of Alabama have anything to do with the dismissal? And I don't know, maybe it'd be best to have an odds maker on to figure out what the odds of two former Louisiana high school football stars who were stolen from the state of Alabama, state of Louisiana, by the head coach of the University of Alabama, what the odds would be that the charge would be dismissed. That's probably the question that's most interesting to me. I don't think anybody would give you anything less than 100 to 1 odds that the charges would have been dropped. But from what I can tell, the prosecutor did not feel very confident in the evidence holding up and leading to a conviction. From what I understand, these two young men were in a parked vehicle along with some other occupants, and apparently the police officers approached the vehicle and saw a handgun in the lap of, I believe, Hootie Jones, who was sitting in the passenger seat. And upon getting everybody out of the vehicle, discovered a small amount of marijuana in the vehicle and a stolen firearm under the driver's seat. I think those are the basic facts that I read in the arrest report that was printed online. But if I'm not mistaken, the vehicle was a rental car. And I think that plays a big factor in the prosecutor's decision in moving forward or not, primarily because in order to prove illegal possession of a firearm, in this case a stolen firearm, you would have to prove that the person actually possessed the stolen firearm. So in a situation where the gun was discovered under the driver's seat, and it's a rental car, I think that the state, the prosecutor, or the state who represents the state in this situation, probably felt like he had a difficult time proving possession. In Alabama, and I'm not familiar with all the laws of the state of Louisiana, but in Alabama, the state or the prosecutor can make a case for constructive possession, meaning, if a person had the opportunity to have possession of the instrument at the time of the arrest, then they could try to prove what's called constructive possession. But in this case, since Mr. Robinson didn't own the vehicle, I think that it would have been pretty easy for a defense attorney to place doubt in the mind of the jury as to whether Mr. Robinson knew the firearm was there or not. That firearm could have been left there by the previous renter of that vehicle. so to speak.
Well, Robert, would they have also have to prove that he knew the gun was stolen? Would you have to prove that as well, or no?
Well, and that's an interesting question. Depending on the charging instrument, which I've not seen, I believe that the charge was possession of a stolen firearm, and in that case, you don't necessarily have to prove that the person knew that the firearm was stolen. Okay, you could be in possession of a stolen handgun. Typically, it's left up to the defense to create doubt in the mind of the jury as to whether the person knew whether it was stolen or not. But in this case, I think that the primary factor in dismissing that charge was that the prosecutor probably had trouble linking Mr. Robinson's knowledge of the gun's presence there in the vehicle at all, and not whether he knew it was stolen or not. If there's a handgun under a seat, then the prosecutor is the one that has to prove that the driver or the person charged with the crime knew that the gun was under the seat. And again, in this case, being that the vehicle was a rented vehicle or a rental vehicle, I think that it'd be pretty easy for a defense attorney to make the case that it's very possible that the previous renter of the vehicle may have left that gun under the seat, and then somebody else gets in the vehicle and drives it away and doesn't know it's there. I think that's the primary factor as far as what I could glean from reading the information on the internet that makes me think that the prosecutor was really wrestling with that part of the case. It's important to remember in all criminal cases that whether we think of the defendant as guilty or innocent or whatever we think of the case is really not material. The defendant comes into the court presumed to be innocent, and it's the prosecutor's job to prove him to be guilty. And that standard, again, the burden of proof being beyond a reasonable doubt. And I think that the prosecutor had a tough nut to crack there in proving that this gentleman knew that the gun was under the seat. And I think it's immaterial whether he knew it was stolen or not, because they would have had to jump the first hurdle before they could have gotten to that.
Hey, Robert, Adam Blankenship here. Got a question for you. Do you think, and we had talked about earlier, there seemed to be 2 other suspects in the car as well, but they were released. Do you think that may have weakened the case or maybe even brought into question the intent for the search warrant at all? Did that play any kind of factor?
I'll take that in 2 different parts. First, the number of occupants of the vehicle, which is what I think you're getting at. The more people you have in a vehicle, of course, the tougher time you have in trying to figure out who possessed what substance or what instrument that may be located in the vehicle. You're going to have more people pointing the finger in more different directions. So that definitely makes it more difficult. As to the intent on the search, from what I understand, the vehicle was parked in a parking lot at a facility that was closed. So I think that the officers probably had reason to believe that they could approach the vehicle, ascertain what was going on. It's my understanding that when they approached the vehicle, the passenger, who I think is Hootie Jones in this situation, let the officers know that he had a gun in his lap. I believe that's what led to the officers looking into it a little bit further instead of just asking the question of, hey, what are you guys doing there? So from what I understand, Mr. Jones was not prosecuted because the gun that was in his possession or on his person or in his lap was not illegal for him to possess the firearm in the vehicle according to the laws of Louisiana. So again, I think the other dynamic that's worth mentioning here is that the charges are really brought to the prosecutor by the officers. The prosecutor takes the information in the arrest report and brings a complaint, a formal complaint. At that point, there's generally some further investigation into the facts of the case by the prosecutor, who's then going to take it and try to take the case to trial. And I think it's at that point that prosecutor said, whoa, wait a second, I don't know that we have enough to link their actions to the factors that are necessary to prove the charges that are brought here. I think that's what's going through his mind, because the laws are really designed to prevent people from being convicted, and it really places a heavy burden on the state to prove that case, again, beyond a reasonable doubt, which that statement gets thrown around a lot, beyond a reasonable doubt, but it's difficult to do that in a situation where somebody doesn't give a confession, for example. I mean, how are you really going to prove that he knew the gun was under the seat, for example? That to me is the whole crux of the issue for the prosecutor. He evidently was very confident that he could not prove that he knew the gun was under the seat.
Well, and then Robert, at that point, if you throw out this the gun charge, illegal gun charge, really what you're left with is 4 guys with a very small amount of marijuana. And I guess the thinking is, hey, I mean, this isn't even a battle we want to fight. And really, is it that irregular that a case that turns into something very minor with marijuana just never gets seen to the light of day?
Well, yeah, I think that's becoming more common, and as far as what we see with so many states legalizing that substance, prosecutors in most states have a lot bigger crimes to worry about, and not to minimize somebody possessing an illegal substance, but the fact that you've got so many people in a vehicle, such a small amount of a substance, you've got all these people pointing the finger at each other, and the prosecutor, from what I read on the internet, basically said that it was going to be difficult to prove who actually had possession of the marijuana. And again, the key factor is that that vehicle was not registered to any of the people that were in the vehicle. So if it was registered to Cam Robinson, I would almost guarantee you that charge would have stuck, because the laws in most states make it constructive possession, meaning it doesn't matter whether you actually had it in your pocket or not. If it's your vehicle and the substance is found in your vehicle, you're going to be on the hook for it unless somebody pipes up and says it was theirs. So I really think that the fact that it was a rental vehicle probably is the biggest factor in this whole situation.
Well, Robert, thanks so much for being with us and clearing up a lot of this. We appreciate your insight, buddy.